I like this one because it was very stressful for everyone, including us. But we felt that the client was with us in this fight, and that's a fight that doesn't happen every day. So the client receives, it was just now, by the way, 2 weeks ago, the client receives a claim for design patent infringement. So do you know what a design patent is? It kind of protects the shape of the product. Does anybody, by the way, anyone has a design patent? Raise your hand if you have one. 1, 2. Okay, if you have an innovative product, you should definitely register a design patent. It protects it pretty well. The owner of the design patent files a complaint against our client, who is a competitor, okay? And just now on the holiday season, right? But then it was rejected because there's a difference between our client's product and that design patent. So it was rejected. What do? Usually they kind of give up. In this case, they filed a lawsuit against our client for design patent infringement. We looked at it and we said, listen, there's no infringement. There's just no infringement. It's very far from the design patent. There's no infringement. Let us call the lawyer. It's going to be fast. No worries. We call the lawyer. We tell him, listen, you know there's no infringement. And he was saying, yes, but my client wants $20K, and we want you to stop selling the product, and then we'll retract the lawsuit. But we said, but there's no infringement. And he said, yes, and we felt he was very hesitant, and it was kind of a young lawyer. So we came back to our client, and we said, there's 2 options. One, we negotiate, okay? He wants $20K, you don't want to have any issues, we can negotiate, probably we can close for, I don't know, $10K. But don't do it, because you're not infringing, okay? In this case, trust us, you're not infringing, let's resolve it otherwise. And we used an option that isn't used very often, and that's the Rule 11 motion. So you can file to the court, you can file a motion saying there's no evidence to support this lawsuit, and this lawsuit is only here to harass the defendant. And if you win, it's amazing, because one, there are sanctions against the person who filed it, and 2, there are also sanctions against the attorney. Okay? The problem is that the attorney hates you from that moment. They'll probably never negotiate with you, and if you lose, the court hates you. Okay? So it's really all in. But in this particular case, we looked at the case, we looked at the files, and we saw they never filed any complaints. And this particular attorney actually never filed any lawsuit in his life. Let's do it. So we did it, and that was between Christmas and New Year. And we send a letter, an email to the counterparty. We are about to file the motion. We're going to send it right after New Year, so you have a week to dismiss the lawsuit. Maybe 24 hours later, we receive a dismissal of that lawsuit. The client, by the way, we really had to convince the client to do it. It's a couple. One of them said, "Let's forget about it. It's a good product, but not our best product. Why would we take the chance? We would have to litigate." The other one said, "I have a good feeling about it. Let's do it." So we were all in. I call it all in because they were like, "Let's do it." And then that ended well. It could have not ended well. And again, it doesn't apply to any case. A lot of our clients here ask us sometimes about Voris and you know who I'm talking about first sale doctrine and other types of. Sometimes it is relevant, but in this particular case, it was the right thing to do and at the right time. So I like this case in particular.